colleagues, friends, esteemed guests. It's my pleasure to welcome you to the first of the inaugural lecture series that celebrates appointment of professors from the College of Law. The inaugural lectures are a chance to celebrate the accomplishments of our senior academic colleagues on their appointments to professor. Tonight, I have the great honor of introducing you to two professors who have been exemplary in their commitment to SOAS and whose work has been quite different and in quite different ways have contributed to the advancement of law, not only at SOAS, but across the UK and globally. Professors Emilia Onyema and Professor Lutz Oette. This evening, you'll hear from one professor of international commercial law, expert in international arbitration, duly qualified in Nigeria and England and Wales, founder of the director of an exciting new center on arbitration and dispute resolution, who has raised the profile of our college in the world of arbitration. You'll also hear from a professor of international human rights law, who has literally written the book on torture, who co-directs our Human Rights Center and our clinic. Both colleagues are exceptional human beings whose collegiality and commitment to the College of Law and to SOAS are palpable. The respect that we have for these colleagues is well-deserved. I won't speak much about them because we have invited testimonial speakers who will introduce them. Our first inaugural lecture will be given by Professor Emilia Onyema, who was appointed professor in 2021, and her lecture is entitled Africa and International Arbitration, Friend or Foe. And our second inaugural lecture will be held by Professor Lutz Oette, who was appointed to professor also in 2021, and his lecture is entitled Human Rights in Crisis. Each inaugural lecture will last around 25 to 30 minutes and will be introduced by a testimonial speaker. So without further ado, we're joined by video by our first testimonial speaker, who is Professor Julian D.M. Liu, who will introduce Professor Onyema. Professor Julian D.M. Liu is head of the School of International Arbitration at Queen Mary University of London since its creation in 1985. He's a practicing lawyer and arbitrator. His research interests are in international commercial arbitration and private international law. He has written extensively on many different aspects of international arbitration and trade law, and has authored and edited several books and written innumerable articles on international arbitration. He is the UK member of the International Court of Arbitration of the International Chamber of Commerce, the ICC, and a member of the ICC Commission on International Arbitration and the Council of the ICC Institute of World Business Law. Please welcome Professor Julian Liu, who will provide his testimonial and introduce Professor Onyema. Over to you, Professor Liu.
Pleasure and an honor to have this opportunity to support, endorse and commend Professor Dr. Emilia Onyema as she formally takes on the chair as Professor of International Commercial Law at SOAS, University of London. I have known Emilia Onyema for over a quarter of a century. That's a long time. I have seen her start, rise and soar. In 2000, Emilia came to attend my lectures at the School of International Arbitration at the Centre for Commercial Law Studies at Queen Mary University of London. This was part of the then existing London University Intercollegiate Master of Laws programme. Emilia successfully achieved her LLM in 2001. More pertinently, Emilia embarked on research for her doctorate on the subject of the arbitrator's contract in international arbitration. This focused on the legal nature of the relationship between arbitrators and the parties whose dispute they are selected and appointed to determine. Emilia was awarded a doctorate in 2007. Her thesis was subsequently published and is a considered authority on this subject. This is a legally difficult subject, bridging the conflict between the authority and power of arbitrators as compared to national court judges. This has important practical implications. Arbitrators are independent individuals selected and appointed by the parties directly or indirectly through a system selected by the parties. However, the arbitrator's role and authority is different to that of national court judges, even if the dispute resolution aspect is the same. Arbitrators are not judges, with the authority which national laws give judges. However, the role of arbitrators is crucial to the success of international arbitration, both generally and in every specific case. Also, in 2007, after serving her PhD, Emilia joined SOAS, teaching international commercial law subjects, including international commercial and investment arbitration and international trade law. Prior to coming to London, Emilia received her first degree in LLB honours from the University of Jos in Nigeria and qualified as a barrister and solicitor in Nigeria, where she practiced for several years. She has also qualified as a solicitor in England and Wales. Emilia has published extensively on a wide range of subjects, but focused on commercial law, international arbitration, and the African and Middle Eastern regions. She's been a visiting professor to several universities, including in Cape Town and Switzerland. Emilia is also involved in many international arbitration committees and organizations around the world, including the Chartered Institute of Arbitrators, the Permanent Court of Arbitration, and panels of arbitrators around the world. Not surprisingly, in addition to her success in the academic world, Emilia has also sought and been appointed to be an arbitrator by different arbitration institutions crossing areas of international commerce and investment. I must acknowledge that it is a great thrill and personal satisfaction for a teacher to follow and witness a student do well and rise to the top. For me, therefore, Emilia's inauguration as a professor is a source of pride as she achieves her undoubted potential. Emilia's success comes from her enthusiasm and hard work. She has a love of the subject and an interest to dig down to understand more and develop her ideas. This enables her to pass on these ideas to the students who will learn not just from her erudition, but also from her enthusiasm and enjoyment of the subject. I regret that due to commitments away from London, I cannot participate and attend Emilia's inaugural lecture on 27 November. However, I'm delighted and honoured to have this opportunity to participate in this inauguration by this prepared recorded message commending Emilia to SOAS for this appointment. I'm sure SOAS knows and appreciates Emilia's exceptional skills and is a great inspiration and academic driver for SOAS. Emilia is increasingly recognised in the areas of international commercial and investment arbitration as an academic, as a teacher, and as an arbitrator. As Emilia continues to make her name internationally, SOAS will share in her success and reputation. It is a wonderful appointment for her personally, well deserved, as she has proved over the years her abilities, academic output, and teaching excellence. Congratulations, Professor Dr. Emilia Onyema. I'm honoured and delighted to have you as a colleague and a friend. I wish you continued success and all good fortune as you go from strength to strength with your scholarship and your teaching.
Thank you so very much to Julian for those kind words, and thank you to all of you for attending. So this lecture is, you already have the title. It is Africa and International Arbitration, Friend or Foe. The lecture will explore the evolutionary changes and transformations in the role of Africans in international arbitration, both as parties and as arbitrators. It will argue that the international arbitration community is slowly embracing African practitioners as equals, while Africans as parties appear to be turning away from the process of arbitration, and I would explain why. I do have an outline. So I want to say a few more words about my background and my SOAS journey. Then I appreciate that quite a few people in the room, this is a dual event, have no clue what arbitration is. So I will try to explain to you what arbitration is and why it is so important. I would try to explain to you what arbitrators do as global decision makers who shape global commercial and investment rules. I would then focus on the participation of African practitioners as arbitrators so that I can set out for you what the gap is and what the problem is, which is the limited representation of domestic know-how of African parties and arbitrators as part of the legitimate expectation of African parties. I would then focus on the research, my research, to show the influence and impact of my research in finding solutions to the identified problem, tell you what I plan to do next, and I will conclude, hopefully within 25 minutes. So my background at SOAS, University of London. So I was recruited by Professor Lynn Welchman, who I call my chief, in 2007, primarily to develop the arbitration offering here at SOAS. I have done this. I have developed 2 postgraduate taught modules on international arbitration. We have a postgraduate taught module on international investment law. And in 2017, for the first time within the University of London colleges on the undergrad, we started teaching an introduction to the law of commercial arbitration, which is fantastic. And we got students from across the various colleges. I have also supervised PhD students, and I'm going to mention one of them later on, to completion on arbitration-focused topics. And so what have I received in return from SOAS? In return, SOAS gave me the opportunity to conduct research in arbitration in our SOAS regions of Africa, Asia, and the Middle East, with a primary focus on states in Africa and the Middle East. I can therefore say that it has been a mutually beneficial relationship. The highlight for me came in 2013 when the management of SOAS approved the SOAS Arbitration and Dispute Resolution Center, which is a research and knowledge exchange center with focus on arbitration and other forms of dispute resolution processes. So under this center, we have continued the work we're doing around knowledge exchange about arbitration within our regions and about our regions. And we have continued to promote SOAS in arbitration-related events in these regions. We have webinars, conferences, research publications, and these have further consolidated our work on these topics at SOAS. It has been gratifying meeting people who did not know much about SOAS until they encountered our center and the work that we do. So I'm now going to talk, so that's my story with SOAS. So it's been mutually beneficial. So we're both happy. And now my dean is here, so hopefully he's happy. Now I'm going to turn to the content of my presentation. So what is arbitration? Julian already spoke a little bit on this. But arbitration is a legal mechanism for the private resolution of disputes outside of domestic courts. It is used primarily in cross-border commercial and investment disputes between parties such as corporations and states, states being governments. Decisions that are made in arbitration are recognized by various states as legally binding on the parties and determinative of the disputes between the parties. Sovereign states support the process by enforcing such decisions with very limited scope for non-enforcement. And this is what makes it really important, that arbitrators, they make rules. They determine how international commerce and investment progresses, how those rules are interpreted, which is really important. The modern arbitration regime, modern because arbitration as a process is not new on the continent of Africa. But what is modern is the fact that the current regime is underpinned by various statutes and conventions, the most important of which is the 1958 New York Convention, which as at today has been ratified and implemented by 172 states across the world. 42 of our 54 African states are parties to this convention. The second point around modern arbitration regime in Africa is the enactment of domestic arbitration laws. And these govern arbitration proceedings connected to or seated in African countries. The 54 African jurisdictions have either a bespoke law on arbitration or one that is part of a larger suite of laws, which would also cover conciliation and mediation. The United Nations supports this regime through its Commission on International Trade Law, UNCITRAL, and UNCITRAL devised a model law on international commercial arbitration, which is meant to be the benchmark in most jurisdictions or internationally. And this has been adopted in 127 jurisdictions in 93 countries, of which 13 are African states. Finally, we do have what we call the OHODA regime. So that's the Organization for the Harmonization of Business Laws in Africa, and they have a modern 2017 Uniform Arbitration Act so that the same law applies in those 17 jurisdictions. All of this information effectively show that African states have actively engaged with the modernization of their laws that govern arbitration, and they continue to do so. So the importance for me of arbitration is threefold in this context. The first one is that it is recognized as the dispute resolution of choice for cross-border disputes. And the reasons vary, but primarily because disputing parties would prefer to avoid the domestic courts of their opposing party, which may be from a lack of confidence or knowledge of the courts, and to avoid home advantage by one of the parties. So they opt for a neutral mechanism, and that neutral mechanism is arbitration. The second lies in the legal currency of the decision made by arbitrators, the same value as a final court judgment, which is presumptively final and binding on the parties, giving it res judicata effect. The third is that the parties choose their decision maker, who is known as the arbitrator. There is no court, domestic or international, that you go to where you can choose your own judge that determines your case. But in arbitration, you can do that. And that is such an important right that parties have. So the effect of all of this is that the arbitrator, though an individual and a private individual, private citizen like myself, through the exercise of the judicial function, exerts great powers in interpreting legislation and legal rules, which may weigh heavily on the development of the law. It is true that we do not have the principle of precedence, because each tribunal is independent, is different, and stands on its own. However, there is need for consistency of decision makings in similar facts and where similar laws apply, so that tribunals in similar situations may be persuaded through earlier decisions made by other tribunals. And this you can see easily in investor-state arbitration. So this is where we then have the disparity with the participation of African arbitrators in the international arbitration regime. We have clear data that shows from institutions the number of African parties that participate as disputants. And by the time you compare that with the numbers that act as arbitrators, there is a massive disparity. So I'm going to quote one of my favorite jurists, Judge Yusuf Abdul Kawi, who was the former president of the International Court of Justice. At the very first ICA is like the Premier League, Champions League of arbitration. And for the first time, we had an ICA Congress in Africa, and it held in Mauritius in 2014. And this is what he said, because this quote really best captures the work that I do and why the work is really important. He says, the lack of participation of African arbitrators in arbitral proceedings involving an African party constitutes a negative factor with respect to the potential contribution of arbitration to the rule of law in Africa. The continued absence of Africans from the process raises issues of legitimacy and affects not only standard setting and knowledge transmission, but also the taking of ownership of arbitration by African countries as an ADR mechanism, ADR being alternative dispute resolution for the newbies in the room, mechanism. When the law governing arbitration involving African parties is interpreted and applied without the participation of Africans, there is both a manifest absence of African perspectives in the development of that law and the lack of potential contribution of Africans to the evolution of its own rules. So that is the problem. And so, what have we done about the problem? The advantage of being an academic is that you see a gap, you see a problem, then you try to figure out how to fix it. The first thing that I did was a research project which I designed in 2014. So it ran over 4 years. And the idea was, I'm coming from the world of legal practice, where I had already done a couple of arbitrations. So I knew that there were Africans who sat as arbitrators and that we did arbitration, commercial arbitration. But you'd attend conferences, and what you would hear is that there is no expertise in Africa. You would hear that the courts are hostile towards arbitration and that there is poor legal infrastructure. And you sit in the conference and you're sort of, I'm holding myself so that I don't explode and say, where are you getting all of this? Because it's a question of perception. But the perception is strong and strongly held. And so I asked myself, what can I do? The first thing to do is to figure out who does what. What exactly are we doing on the continent? Who is doing what? It will be easier for the Kenyan party to appoint an English KC than to appoint a Nigerian, even though they're all common law jurisdictions. Simply because the Kenyan knows the English KC, but does not know anybody in Nigeria. And so what we then did was, consciously, the conferences were going to be held on the continent. There were going to be speakers from the continent and internationally. And that has been the way my research is done. And so we had the first one at the Secretariat of the Africa Union at Addis Ababa. I'm going to tell you the numbers just so that you can see the incremental value of the conference. So we had 61 participants at that conference in 2015. And there we explored the role of arbitration centers. And we then, in the following year, in 2016, we had the second conference in Lagos. I'm Nigerian, in Lagos. And we had 115 participants. And in Lagos, we explored the role of judges and national courts. The third conference was in Cairo, Egypt, and we had 177 participants. And we examined the substantive content of arbitration laws on the continent. The fourth conference was in Rwanda, in Kigali, and we had 250 participants. And we said that was the end of the conference. The community on the continent said, we now know ourselves, and we want the conferences to carry on. So I'm going to read to you a testimonial from the then president of the East African Community Court of Justice, Dr. Emmanuel Ugerashibuja, and he said at our Arusha conference in 2019, he said, let me single out Dr. Emilia Onyema, who is the mind behind this SOAS series, which have created a forum that fosters cooperation, collaboration, and effective interchange of ideas amongst the African arbitration practitioners and even those beyond Africa. That is testament to the sort of work that we do. So what was the outcome? What did we get out of these conferences? The output was 2 edited book collections published by Clover, 4 sets of conference papers from over 40 authors, all online. And this was one of our major impact case studies for the last REF, and it was highly, highly recognized. Following that, we said that is not enough. We need an African pledge. And the idea behind the African pledge is for practitioners to sign up to the pledge and start with by saying, where you have an Africa-connected dispute, you will actively search for African arbitrators to appoint. And we've had that pledge going since 2019. We then moved on to the other side of the coin. If you're asking people to appoint Africans, you have to be sure that they have the relevant skills. Nobody is going to sacrifice their dispute. And so we started with our advocacy training for counsel that appear in arbitrations. And this, I would really love for you to hear the numbers. So between 2022 and 2023, we went to 12 African countries. It's important that my students hear this so that they understand why I'm hardly around. We went to 12 African countries. We had part funding from the Africa Legal Support Facility of the Africa Development Bank. And that's something else that I insist upon, that funding has to come from the continent, from law firms on the continent and banks on the continent. And we're getting that done. And over this 2-year period, we trained 166 lawyers at various career levels, from associates to partners. We trained them in Arabic, English, French, and Portuguese languages. I only speak English. I only speak English. What this means is that we relied on support from both foreign and domestic practitioners, primarily international law firms, with expertise and relevant language skills. We also worked with domestic arbitration institutions to deliver the training in each country. And this work is going to continue because the vision is to run it in the 54 African countries, and it will be done. So I remain grateful to all of these wonderful colleagues, too numerous to mention tonight, who bought into the idea, gave advice, opened doors for us, physically participated, and funded some of these projects. I wasn't going to rest because that was not enough. So we started the biannual SOAS Arbitration in Africa survey reports. The idea with the survey reports is to include the African voices into the discourses that we were having within international arbitration. And so we've had 2018, 2020, 2022, 2024. They're all online. And the next one is going to be in 2026. But this year, 2025, we decided to do an off-cycle research to figure out who were the females who sit as international arbitrators on the African continent. Because the research we had done earlier showed exactly the same limitations that we have internationally is mirrored domestically in the continent. And so that research has been done. We've done the report, so it's out for design. We should publish next month. So in recognition of my work to drive this inclusion of African practitioners in international arbitration, the International Institute for Conflict Prevention and Resolution out of the United States, pre-Trump, by the way, in March 2024, awarded their prestigious Outstanding Contribution to Diversity in ADR to me. So those are like the friendly stuff that we see. The question then becomes, what about us SOAS? There are two major points, sticky points, and this has been borne out by research: the cost of arbitration. The cost of arbitration has become just too much, not only for African parties, but primarily for small and medium-sized enterprises who are now turning their backs on arbitration and going back to their local courts or mediation. The second is in relation to states. The sorts of the volume, the large damages that states are being burdened by is becoming a huge problem. And those are things that we do need to think about. So what is next for me? How am I doing for time? You're happy? Perfect. So what is next for me? Last year, I delivered the Roebuck public lecture at the Chartered Institute of Arbitrators. And at that lecture, I raised concerns with the inability of local communities directly and adversely affected by the activities of foreign investors, primarily in the extractive sector, to meaningfully participate in investor-state arbitrations. The current regime arising from the consensual nature of arbitration means that such communities are not considered as disputing parties. They can submit amicus briefs in such arbitrations, but their participation is severely limited and usually at the discretion of the parties themselves, so the foreign investor and the state, who may not have an interest in their participation, and of course the tribunal. So I argued at the Roebuck lecture that the current regime is not satisfactory for the primary reason that these local communities suffer the damage or loss emanating from the actions of both their home state and the investors. So for example, their displacement, the destruction or pollution of their habitat and environment, and disruption of their way of life. A direct right of audience or status before the tribunal will ensure they can ventilate issues that concern them directly and will not need to rely on those of public interest litigators and NGOs whose interests may not align with theirs. The key question, the limitation we all have is how. How do you give effect to this suggestion? And that is what the research will focus on. There are other colleagues who are already working on similar issues or questions out of South America. So it's to work on that. So to conclude, my research over the years has contributed to our understanding of the participation of African arbitration practitioners in international arbitration. It has led to the gradual increase in the appointment of African practitioners as arbitrators in both Africa Connected and non-Africa connected disputes. For those of you interested, there's a case against Russia, the Wintershall case. And Russia has now commenced a suit against the arbitrators. And the presiding arbitrator is the foremost female Nigerian arbitrator. It has nothing. It's not an Africa-connected dispute. But that dispute is worth 1.7 billion euros. That is where we want to be. And that is what a level playing field, equality of arms, that is what we are saying. That we have the expertise, then we must. We need to have a seat on the table. And that is really important. So I sort of shared that. I was so excited, when she was appointed by 2 white male European arbitrators. And she was appointed, she's Nigerian, black, senior lawyer, female, like myself. And she is the presiding arbitrator. And that is amazing. So we are making progress, and that is massively important. So the work I have done is important and enduring, is an important and enduring contribution, for which various awards and recognitions have been given to me, but which would not have been possible without the support of many arbitration colleagues, to whom I say thank you. I also thank the management committee members of our SOAS Arbitration and Dispute Resolution Center. And I have a very special PhD student, Mr. Mark Wasuna, who is an associate lecturer, whose excellent, amazing support of teaching on my modules have also freed me up to undertake this work, of which I am particularly passionate. And Mark, I am very grateful. Thank you. Finally, I do have a family. It sounds like I don't, but I do. Finally, immeasurable thanks to my family represented here today by my niece and my goddaughter, Chim Emuche, but particular recognition of my late parents. So my late parents would have been very proud. I'm the last child out of 8 siblings, and I am a girl. My mother insisted that all her daughters would get the same education that her sons got. And that's why I'm standing before you. So a huge thank you to my late parents, His Royal Highness Igwe Eze and Odobo Onyema, who both actively supported traditional methods of resolving disputes within our communities in Nigeria. I know that they will be very proud, and I am grateful for all the support. I've never lacked anything in my life, and that's because of my parents. And so thank you very much for your patience, and thank you, SOAS. Thank you to the College of Law. I can see lots of my colleagues. Thank you. You're very kind to me. Thank you very much.
Yep. Got it. Thank you, Emilia, for that wonderful lecture and for giving us a sense of your achievements and your journey. So thank you for that. So without further ado, I'll get on to our next testimonial speaker for our next inaugural lecture. So please welcome Professor Lynn Welshman to give her a testimonial for Lutz Oette. I'm going to introduce her. People in this room may know Professor Welshman, but I'm going to introduce her and tell you about So Professor Lynn Welshman is a professor of law with particular reference to the Middle East and North Africa. She was recruited to SOAS as a lecturer in Islamic law in 1997. She currently convenes gender law and society in the Middle East and North Africa, and co-convenes with Lutz and our colleague Michelle Kelsall the flagship International Human Rights Clinic, for which she was joint winner of the SOAS Director's Prize for Inspirational Teaching in 2019. She has been the law school's head of department and held a number of senior positions in the department and at the SOAS level. Lynn is currently finishing her term of appointment to the UN Independent International Commission of Inquiry on the Syrian Arab Republic, on which she has served since 2021. She studied Arabic and Persian at Clare College with a year in Cairo, where she supported herself through teaching English, and after graduating from Cambridge as an honorary scholar with college and faculty prizes, she went to Birzeit University and then to work with Al-Haq, the first Palestinian human rights organization in Ramallah. She came to SOAS School of Law for a PhD on family law and the Sharia courts in the West Bank, funded by the British Academy. She then worked with other Palestinian human rights groups and has also worked with international human rights groups, mostly in the Middle East and North Africa, but occasionally elsewhere, for example, in Haiti and Rwanda, before and also since coming to work at SOAS. Please welcome Professor Lynn Welshman to give her testimonial.
Thank you, Eddie. I wasn't expecting that. Good evening, everybody. I was absolutely delighted when Professor Lutz Oette, I will call him Lutz soon, because I'm on a word limit, did me the honor, and it really is an honor, Lutz, for me, of inviting me to present this testimonial on the occasion of his inaugural professorial lecture. Lutz joined us at SOAS as a lecturer in human rights law in 2008 when I was head of what was then the law department. So I'm always happy to shamelessly claim complete credit for his recruitment and to bask in the reflected glory of his many achievements since then. And his achievements really are many. I would also add that I also, as you heard, recruited Emilia, so I'm having a great night. I'm really having a great time so far. I'm basking all over. So, Lutz is a scholar, a legal practitioner, qualified in Germany, and a teacher of extraordinary skills, integrity, and reach. I stand in awe of him, even though he's a friend. It's hard to combine the two sometimes. He did his LLM at UCL, not at SOAS, but we'll pass over that, and his PhD at Cologne. He joined us from after some 15 years as counsel with Redress, the UK-based NGO that works for an end to torture and for justice and reparation for survivors of torture, and that partners to this purpose with like-minded NGOs and legal groups across the world. I say that in some detail because the work that Lutz did there showed broadly and with hindsight the same two research priorities and themes that have characterized his work at SOAS: prohibition of torture and reparation for the same, and human rights and justice in Sudan. At SOAS, Lutz has taught hundreds of students, and I think some feel hundreds of modules, but it's not. And for some years, he's been convening and exponentially developing the LLM Human Rights, Law and Justice program. He is indefatigably collegial and has played various key roles in the SOAS School, now College of Law, including leadership roles in research and in teaching delivery, and doing stints as co-head of law and on our management committee. He was editor of the venerable SOAS Journal of African Law for 6 years and has been an elected member of Senate since 2022. He's also had other roles in SOAS, the school. He's also co-chair with Dr. Michelle Kelsall of the Centre for Human Rights Law, and in this capacity has really put the centre and therefore SOAS on the human rights policy map, with submissions, interventions to various regional mechanisms, the African Court, the African Commission, the UN Committee, all sorts of UN committees. So it's really been a stunning sort of succession of interventions in the CIHRL's name. In his own standing, he's made a huge contribution, policy-wise also, to the development of the UN Manual on the Effective Investigation and Documentation of Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment, aka the Istanbul Protocol of 2022, which is a large document and an extremely, I think it was about 4 years' work that Lutz put into that alongside his work at SOAS and everything else. He's also been involved in various networks with two themes in Britain and elsewhere along the years, and alongside his work to do with prohibition of torture and to do with the Sudan work. In this work, you see the Centre for Human Rights Law, alongside his efforts as co-convener with me of the SOAS International Human Rights Clinic, Professor Oette maintains and expands his networks amongst human rights activists and organisations, and at the same time his commitments to them. It's very much a two-way thing. It's not make contacts so you can get, it's very much a two-way relationship with a lot of investment in how you build relationships and sustain them. The meanings of these partnerships and the human relationships and understandings that underpin them loom particularly large in our current cruel times. Lutz is one of the most principled people I have worked with. Lutz invests deeply in collaborative projects. His research, writing, and advocacy projects are replete with publications and interventions co-authored with colleagues, with younger scholars, and some older, because I did one with him, but he was younger scholars, with lawyers and activists outside academia. Reading the list of his outputs overall, his publication in particular, is frankly exhausting. You could, I have 5 minutes to do this. I could have used them up by simply reading out the list of his publications. But I would point up to his 2024 monograph, The Transformation of the Prohibition of Torture in International Law, which truly is the work on this at the moment, and International Human Rights Law and Practice, co-authored with Ilias Bantakis. This is the leading textbook on the subject. It was first published in 2013 and is now in its 6th iteration, each edition growing in scope, in texts, in mechanisms, in voices, and it has to be said in length, much like the field itself. In this lecture, Human Rights in Crisis, Lutz has promised to, quote, chart the evolution of pertinent debates, situating the contemporary moment in a fundamental polycrisis of and for humanity that brings into sharp focus the nature, role, and effectiveness of human rights law. And he puts law in brackets, which is very interesting. There's no questions after this lecture, by the way, but we can ask him afterwards. In so doing, the lecture pays tribute to visions and revolutionary spirits that inspire, if not represent, counter-hegemonic approaches to human rights. This is a moment, and we need revolutionary spirits. And so, friends, colleagues, students and comrades, I commend to you Professor Lutz Oette to address us on human rights in crisis.
Thank you so much, Lynn. I'm very touched. Words fail me to express my gratitude, love and admiration for you and all you've done over all these years. You embody the very best of SOAS. You bring dedication, passion, rigor and care to your research, teaching and practice, and are a human rights academic activist in the best possible sense. So thank you, Lynn. A lot of work has gone into organizing this event, so big thank you to everyone working tirelessly behind the scenes and here tonight to make it run smoothly. And thank you all for coming. It is wonderful to see my dear family and so many friends, colleagues, present and former, and students, and to spend this occasion with you. Now, we are here to celebrate our achievements, and congratulations to Emilia, Professor Onyema, on your tremendous lecture. For me, becoming a professor has been part of a long, ongoing journey of learning, discovery, and engagement. It is far from being a solitary journey, but one of countless exchanges, encounters, and experiences, and visit many people. All of them are here with me tonight, physically and metaphorically, and speak through me, having made me who I am. There are way too many people to thank personally, so this is for all of you. Let me make a special mention, however, of those who can no longer be with us physically. I miss you, I remember you fondly, and I trust that you are here with us in spirit tonight. Now, I've been thinking long and hard about the topic of my lecture. I could have spoken about torture and ill-treatment, an issue and a scourge that has gripped me for a long time, certainly since joining Redress in 2001. I have reflected on it in numerous publications, culminating in my book published last year, and you see the nice cover there, produced by OUP, the publisher, The Transformation of the Prohibition of Torture in International Law. Equally, I could have focused my work on human rights, law, and justice in Sudan, which could not be more critical. Ever since I first traveled to Khartoum in 2004, the country and the struggle for freedom, peace, and justice of the people I've worked with has been a source of lasting inspiration. Even the Sudanese intelligence and security services, who had prepared a special welcome for us at the time, could not change that equation, on the contrary. In the end, rather than charting my scholarly trajectory, I decided to speak to the development of the wider field I have worked on. Human rights and the systems for their protection are ever more at risk. I will therefore use this lecture as an opportunity to reflect on what we may well call an existential moment for human rights. Now, this is also the moment for a trigger warning. There will be no jokes. This is a serious lecture for serious times. When I studied for my... That was meant to be a joke, but... It's gone missing. Anyhow, when I studied for my Master of Laws in the mid-90s, human rights had, to quote Florian Hoffman, an aura of self-evidence. It did not take long, however, before the human rights paradigm attracted sustained criticism. Critics on the left of the political spectrum, such as Kostas Doudinas, highlighted the ideological and institutional constraints of liberal human rights. Susan Marks and others critiqued the failure to address the structural causes and socio-economic logic of violations. This led authors such as David Kennedy to ask whether the human rights movement itself is part of the problem, by helping to sustain, if not reinforce, problematic power structures. Steve Hopgood, a former SOAS professor, lambasted Western arrogant human rights organization in his widely debated book, The End Times of Human Rights. Another influential account by Samuel Moyn called Human Rights the Last Utopia, portraying it as a shallow movement that only gained momentum when it was endorsed in US foreign policy in the 1970s. Now, this controversial, I should add, interrogation of human rights by Western authors has been paralleled by distinctive Southern voices. They've both critiqued the lack of serious engagement with imperialism in Issa Shifji's early path-breaking book on the African human rights system, and colonial dynamics at work in the field, such as Macau Mutua's famous Western saviors rescuing innocent victims in the global south from their savage governments. Multiple authors, such as Sylvia Tamale, have called for a pluralistic, feminist, and decolonial reorientation of human rights. On the other side of the political spectrum, Eric Posner, for example, has derided human rights as ambiguous, ideological, ineffective hubris. Now, with the rise of so-called populist movements and governments, human rights has become the shorthand for all sorts of apparent evils, from uncontrolled mass migration, free rights for terrorists, to equality gone mad. So you may ask, why talk about human rights in crisis today, when its many purported shortcomings have been endlessly debated and its supposed end has been a constant theme for the last 2 decades or so? One obvious answer would be Palestine. Our colleague Nima Sultani has called the question of Palestine a litmus test for international law and human rights, namely how it engages with imperialism and colonialism as root causes of violations. He published this article in 2022, and subsequent developments suggest there's only one answer. Key actors such as the US, the UK, Germany, and others have failed the litmus test, a point which I shall come back to. This failure must, of course, not be viewed in isolation. It forms part of long-standing power asymmetries characterizing the international legal order. The so-called war on terror commencing in 2001 and the global economic crisis of 2008 heralded a period marked by increasing repression and backlash against human rights. Unbounded neoliberal market ideologies deepen inequalities, and ethno-nationalism has fostered racism, exclusion, and marginalization. Combined with the megaphone of social media, this development has resulted in widespread dehumanization. Equally, it has undermined civic space and deliberative processes, resulting in increasingly binary and polarized worldviews. Meanwhile, the regional and international systems mandated to protect human rights have struggled to be effective. States have pushed back against them, if not openly repudiated their legal obligations. Major armed conflicts have exposed fault lines and a legal order that is simultaneously heavily politicized along multiple hegemonic axes and ineffective in fulfilling its basic functions. Now, is what we are being confronted with then a major crisis for the international legal order in general and human rights in particular? And if so, what are we to make of this crisis? This question has been the subject of an ongoing conversation at the SOAS Center for Human Rights Law. Indeed, human rights in crisis are a very thematic focus this year. Allow me therefore to open this conversation up with you and in the form of this inaugural lecture. To begin with, when I talk about human rights, I refer to it both as an idea and a legal field. It is a legal system in which primarily states have committed themselves individually and collectively to uphold certain rights. I also understand it as a discourse, movement, and social practice. It is therefore multifaceted, and we need to be mindful which human rights and law we have in mind when talking about this crisis. Now, crisis is a notion that is used liberally nowadays, perhaps with good reason. For our discussion, we do well to inquire into its meaning more deeply. Tangjia Wang, in an excellent article called A Philosophical Analysis of the Concept of Crisis, reminds us of its Greek origin and use as a medical term. Crisis was understood as the turning point in the course of an illness. It is the point where it is going to be decided whether the patient lives or dies. If we apply this notion to responses to egregious violations as a test for the efficacy of human rights, we can easily see how we live in a decisive moment. It determines, to quote Wang again, the success or failure of a cause. A crisis can, of course, be viewed as both a danger and opportunity. To draw rather freely on the German mystic Meister Eckhart, it might be a moment to die and become and transform oneself. Now, James Dodd captures this transformative potential of a crisis when calling it an experience of necessity. A crisis is a situation where we can go no further or carry on no longer without a fundamental change. In even more dramatic terms, Miguel de Bestegui frames it as a shock to the system such that a return to normality is no longer possible. In such times, according to Wang, crisis helps to adjust ourselves to new situations and to understand ourselves in new ways. Against this background, are we facing a decisive moment for human rights then? The signs are mounting that we do. Human rights, to be effective, rely on a shared consensus, framework, and system able to respond to threats and violations. While it has always been selective and contingent on political factors, there is less support for and consequently face in the system. Several examples could be marshaled to illustrate this point. At present, particularly the weak and inadequate efforts to protect the Sunni population from atrocity crimes. However, few epitomize the point as starkly as the lack of a concerted, effective response to Israel's attacks on Gaza. The failure represents the culmination of deeply embedded power asymmetries and double standards. First, on a human level, a disregard for Palestinian lives and their rights by states, politicians, and in media discourses. Second, a failure to even acknowledge a responsibility to prevent genocide based on a denial, including in the form of indifference, that Israel's attack amounts to genocide or might amount to genocide. This is even though the International Court of Justice has ordered provisional measures based on a plausible risk of genocide in the case of South Africa versus Israel. Third, contorted, if not aggressive, positioning such as on the arrest warrants issued by the International Criminal Court against Benjamin Netanyahu and Yoav Gallant. Fourth, relatedly, pursuing several international law avenues to stop Russia's aggression against Ukraine and hold Russia and its leaders accountable, while effectively denying that pertinent international standards apply in equal measure in respect of Israel's conduct. Fifth, the policing and repression of freedom of speech and the right to protest and to defend human rights. And lastly, normalizing through delayed or meek action, if any, a situation that is visibly unacceptable. Conversely, many people worldwide have expressed their support for an end to the war and genocide and solidarity with the Palestinian cause. This includes institutional support, such as by UN human rights procedures and bodies that have emphasized Palestinian rights and condemned their violations in Gaza and the West Bank for that matter. Now, against this background and the second coming of Trump, the international legal system, even though it has responded through both international courts and human rights bodies, appears powerless and ineffective. This powerlessness is being reinforced by the major financial crisis that the United Nations face, which you only know too well, Lynn, which means that its activities are becoming ever more limited. Consequently, the system risks dying a slow death in which it is being attacked, drained of resources, and abandoned. We can, however, equally view current developments as a sign of the strength of human rights. As one former UN Special Rapporteur remarked in a meeting on the crisis of the international human rights movement in Istanbul last year, the language of human rights is everywhere nowadays. It has therefore become a valuable tool to validate claims, even though this very fact may open it to manipulation and abuse. Social movements such as Black Lives Matter have invoked international human rights law. Human rights organizations have played a critical role in protests and revolutionary movements such as in Sudan and elsewhere. Activists are increasingly looking to hold states, businesses, and others accountable on human rights grounds. Several of these cases have been successful, and there have been important normative developments in human rights jurisprudence and practice. Human rights arguments in litigation have strengthened claims that Israel's conduct amounts to apartheid and genocide. UN human rights reports increasingly address structural factors and wider imperial or colonial relationships. This includes racism, where the UN is slowly waking up to Tendai Achume's call that international lawyers and legal scholars have an immense amount of work to do to interrogate international law as both a site of promise and peril for this extraordinary movement-led transnational racial justice project. Notably, including because of student activism from small island nations, both the Inter-American Court of Human Rights and the International Court of Justice have issued progressive advisory opinions on climate change and human rights in 2025. Now, these developments speak to a more bottom-up, contextualized, critically informed approach to human rights. What are we then to make of these contrasting narratives? As paradoxical as it sounds, they are both right, reflecting a deep ambivalence at the heart of human rights. This ambivalence plays out against the fundamental challenge not only to human rights, but the international order as we know it. We live in times of a polycrisis. Besides the existential climate catastrophe, these crises comprise the drawn-out end of capitalism and its consequences, the weakening of democracy, and with these an erosion of faith in rules and institutions. These simultaneous and often mutually reinforcing crises are a sign of a failure, if not breakdown, of the existing order. They have prompted intense struggles of privilege and power within societies and worldwide. The challenge to the status quo has engendered alternative visions. Challenges to the hegemony of states or certain groups on grounds such as race, gender, or socio-economic inequality abound. However, instead of engendering a rethink, they have all too often prompted highly regressive political responses. Environmentally, politically, socially, and culturally, they risk taking states back to a highly unequal 19th century version of might is right. We are also witnessing the increasing appeal of right-wing dreams to invoke crisis for an exception, which justifies the exercise of unlimited powers. The Nazi jurist Carl Schmitt would feel at home in these circles where we are moving towards a permanent state of exception. Nancy Fraser draws out the link between a crisis and a given order well. It is a moment where participants in a society know that the pressing problems they experience arise not despite, but precisely because of the established order and cannot be solved within it. Then and only then can we speak of crisis in the larger sense of a momentous historical crossroads that demands a decision. We have reached the point where the established order is visibly failing. De Bestegui helpfully remarks that to label something as a crisis is already a call to action. But what should such action look like when it comes to human rights? The plain answer is to pursue alternative visions of how to live and to change the failing order. The difficulty is, of course, how best to do so. A truly legitimate field of human rights must effectively address underlying structural causes of power asymmetries that fuel inequality, marginalization, dehumanization, and multiple violations in their wake. We are already witnessing the emergence of thicker versions of human rights to that end. However, even those rights beg the question whether they can be truly transformative if they rely on given normative and institutional structures and operate within existing systems. The extant human rights system therefore faces an inherent paradox. It relies on current structures to operate, but for human rights to be genuinely recognized and guaranteed, these very structures will have to be questioned, if not overcome. Now, the paradox poses a significant challenge for human rights movement. They face a fast-changing environment in terms of actors, modes of engagement, and the implications of technology. In public discourses, human rights might be complemented, if not replaced, by a closer focus on justice, a notion that may prove to be more compelling. It does not rely on a state-centric system or technical legal standards, is urgent and accommodates wider transformative dimensions. A focus on overcoming colonial, economic, and racial injustice or an intergenerational justice is evocative and clearly has considerable mobilizing potential. In response to this challenge, Cesar Rodriguez Garavito has urged the human rights movement to shift from gatekeeping to symbiosis. He asks us to understand the field of human rights as an ecosystem within which to open spaces for new actors, themes, and strategies. While this is welcome, the crux will be what changes to call for and how to work on them from the context specific to the general international. For both existing legal human rights standards and institutions continue to play an important role. They can serve as sites of struggle and recognition and fora that can limit excesses and bring about at least some change. However, they are only one side in a wider struggle which focuses on collective agency and different formations and modes of governance. There's already a lot to work with, a focus on multiple forms of individual freedom and on collective self-determination of peoples is a case in point. Recognizing pluralism opens space for alternative modes of living. This entails taking seriously as equally valid, if not superior, notions such as indigenous cosmovisions that speak to the interdependency of all living beings and nature. As a human rights lawyer, I find this prospect liberating, not least because it leads us to a richer understanding of Article 1 of the Universal Declaration of Human Rights, which speaks of freedom, equality, dignity, and solidarity. Now, to conclude, we face a momentous challenge. It is not merely a crisis of human rights, but of humanity. We are confronted with a zombie political, economic, and environmental system and way of living that increasingly disrespects human rights and may well continue to drag them and us through its hell. The Sudanese revolution of 2018-2019 is both a heartening and a warning example. The Sudanese revolutionaries were way ahead in their analysis of the country's problems and in their visions for its future. However, in their struggle with reactionary and counter-revolutionary forces within the country and the region, they have not been able, at least to date, to translate this vision into a viable political reality. We all know how this ended, as Sudan is now in the third year of a devastating armed conflict. I want to end by paying tribute to the Sudanese revolutionaries and to all those who have stood up and continue to resist human rights violations and injustice worldwide. Whatever happens in response, affirming their and our humanity in so doing is an inspiration and marker of hope in bleak times. Thank you.
Thank you, Lutz. That ended on a hopeful note, but it's a really big challenge you set up for us, and thank you for your work and for your lecture. Thank you all for attending. It's great to see so many of you, and again, congratulations to my colleagues, Professor Emilia Onyema and Professor Lutz Oette. I'd like to invite everyone over to the atrium for our reception in the Paul Webley wing of Senate House. So what happens now is we process outward. So we will come out the same way we came in, and then we can all head over to the reception. So thanks a lot for joining us.